Hi, everyone. Welcome to the Alzheimer's Foundation of America's monthly Care Connections webinar. My name is Laurel Gumpert, and I'm the Educational Program Coordinator here at AFA, and I am so thrilled to be here with you all today. So thank you for taking the time and joining us today. So before we get into today's webinar, I just want to go through some brief housekeeping. So all lines are currently muted. However, we do highly encourage questions in this webinar, so please just ask away. So on the right-hand corner of your screen, you should see a question box where you can type in any questions that you may have. So I urge you to take advantage of this opportunity. After our guest presentation, we'll have time for a Q&A. So please feel free as the presentation goes on to ask any questions that may pop up in your head, and then we will do our best to address all questions. So let's get started with our guest. We are very lucky today to have a friend of AFA and a familiar face joining us today. So without further ado, I'd love to introduce Matthew Raphan. Matthew Raphan has extensive legal experience in estate planning, estate administration, and guardianship matters in both surrogates and Supreme Court. He is passionate about serving clients, understanding their legal and aging needs, and finding cost-effective, legally sound solutions. Matthew Raphan speaks pro bono in New York City throughout the year in the law firm's legal seminars, explaining and simplifying legal issues facing the elderly population. His seminars and classes have been favorably reviewed by BNY Mellon, Beacon Healthcare, the Swiss Benevolent Society, Time Warner, Credit Suisse, Penn South, and us here at the Alzheimer's Foundation of America, and other smaller groups as well. He is also a registered speaker with CLC's Legal and Financial Speakers Bureau. And like I said before, we are so lucky to have him joining us again. And a big thank you to Raphan Law Partners as well. So thank you for joining us, Matthew. So if you'd like, let's get started.
Thank you so much, Laurel. That was quite an introduction. I hope I can live up to that. That was really nice. Thank you all for joining us today. I hope some of you have been present at my previous talks, and some of this will be a little bit of repeat. And I see some new faces here as well, so some of this might be new to all of you too. Last time I spoke, we delved into estate planning, incapacity planning, and guardianships, with a prime focus on guardianships. And I'm going to touch on those topics again because I think it behooves all of us to really be experts on all of those critical topics. But today's presentation is also going to focus on Medicaid planning and trust planning. So I'll try to weave those two topics in together as best I can. I think it makes the most sense to start with the power of attorney, which, for those of you who are not familiar with the document, it's far and away the most critical document that any of us can have with respect to planning for our own incapacity. And before I get into that, I want to reiterate something that Laurel said. I will talk for about 25 to 30 minutes, and then I'd like to open it up to questions. I'd like this to be as interactive as possible. I think that that makes the presentation that much better. So feel free as I'm talking to type in some questions for Laurel, and she'll get to them in about 30 minutes, and we can have a little bit of back and forth and go from there. So the power of attorney. This is a document where we can enable someone called an agent to act on our behalf if we lose the ability to handle our financial affairs. So for instance, if I become unable to pay my bills, pay my rent, handle my investments, handle my retirement accounts, if I don't have a power of attorney, there is likely going to be a void, and those financial matters will go unattended to, which can be hugely problematic, as you can probably imagine. So thankfully, in all 50 states, the law allows us to nominate someone to handle those affairs for us. And the mechanism that enables us to do that is the power of attorney. As Laurel mentioned, I practice in New York. We're based in New York City. So, and I know this is a national audience, and many of you are, from all 50 states. The laws in each respective state vary significantly with respect to all of these issues that I'll be talking about. But conceptually, they really are pretty similar throughout the states. So, there may be some details that vary based on where you live, but by and large, I'm going to try to speak as generally as I can. So if you have specific questions and you're not in New York State about your specific state's laws, I do suggest that you reach out to local counsel near you and get some, tailored advice based on where you live. Sorry for that anecdote. So the power of attorney, again, deals with financial matters. It's extremely critical, and I'll explain why, that each of us have a power of attorney. And I know all of you here who are, associated with the Alzheimer's Association definitely already have this. So it's all repeat to all of you, I'm sure. But, in New York State, we have what's called a statutory form, which means that our elected legislature drafts our power of attorney, and everyone in the state has the same form. That's different than in other states. For instance, in New Jersey, there is no statutory form, so everyone can have their own power of attorney, and draft it themselves. And one doesn't necessarily have to be identical to the next. But here in New York, we all have the same form. You can appoint more than one person to act on your behalf as agent. You can have people acting together concurrently, or you can have people acting in succession, meaning you can have your friend as the primary agent and your neighbor as the backup in case your friend is unavailable. So keep that in mind, when you're doing the power of attorney. The reason why the power of attorney is so critical to have is that if we become incapacitated and unable to handle our affairs, and there's that void that occurs that I touched on earlier, and our bills are going unpaid, and we're being evicted from our home, and our life is turning into shambles financially, there's no one with the ability to help us. The only recourse is for a court to appoint a guardian for us. And that is something that all of us should really seek to avoid. And the latest high-profile example of this, of course, was Britney Spears. For those of you who have been following that case, that scenario, Britney is a pop star, of course, and a number of years ago, she was dealing with some sort of mental impairments, I guess I'll say, and she needed help. And her family petitioned the court in California to appoint a conservator for her. By the way, conservator and guardian are generally synonymous. Here in New York, we use the term guardian of the person or the property. In other states, like California, they use the term conservator. But if you hear them, they're interchangeable, those two terms. In any event, while that guardianship may have been appropriate at the time, based on what Britney Spears has alleged in court filings and in the public, there was rampant abuse in that guardianship. She was unable to make any decisions with respect to her lifestyle, her finances, her medical care, if she traveled, when she worked. She essentially lost all of her civil rights. And that's the essence of a guardianship. When a guardian is appointed for us by a court, the court is depriving us of our civil rights. We no longer have the ability to handle our money. We lose access to our bank accounts. We don't have control over where we live, where we travel, who we see, who visits us. The guardian has the authority to place us in a facility, a nursing home, take us out of our home, invest our money in a way that they think is appropriate and not necessarily what we feel is appropriate. this is a catastrophic scenario. And of course, I have to, certainly mention that guardianships can be fantastic and can be great and appropriate for those of us who lose capacity and are in danger financially, personally, or otherwise. A guardianship can be a lifesaver. I serve as guardian for many people. And, of course, we try our best to, give our wards the best quality of life that we can, and manage their money effectively and prudently so that it lasts. But not all guardians are good, as we saw in the Britney Spears case. So it can be a quote unquote nightmare. Sorry to scare you guys. I know it's nowhere near Halloween yet. I know this is a little scary, but I bring this up because there's a real, true, surefire, easy way to avoid this. And the way we do that is by having a power of attorney and a healthcare proxy, which I'll touch on in a minute. At least in New York, if somebody petitions the court to have a guardian appointed for me, hypothetically, and the judge sees that I have done a power of attorney and a healthcare proxy, and I've appointed my own people to act on my behalf, the court will throw the case out. The court will say, hey, Matthew, you've appointed Mary Jane to act as your agent. She's acting appropriately. You don't need a guardian. So, and that can save me not only tens of thousands of dollars in legal fees, but the heartache of having someone go through all of my stuff and parse through my affairs and ultimately have control over my life. And that someone is not the person who I have appointed and chosen. So the law gives us this very powerful tool to choose who we would like to serve on our behalf. And I hope that all of you take advantage of that because it's so critical. And I hope I didn't scare everyone too much. The healthcare proxy, I want to touch on this briefly also. It's very similar to the power of attorney in that we're appointing someone to handle our affairs, but in this case, it's medical-based affairs. So in other words, who is going to make decisions about our healthcare, about medication, surgery? Who's going to speak to our doctors if we can't speak on our own behalf? That's the purview of the healthcare proxy. And I just want to tell you all a little story about the importance of a healthcare proxy. And in order to do that, I have to talk about the living will, also known as the do not resuscitate, or DNR in some states. So these days, most people feel, at least we found in our practice, that they would not want to be kept alive artificially via life support if they are in a state of permanent unconsciousness and doctors feel that there's no reasonable chance that they'll ever return to any quality of life. There comes a time where a choice needs to be made. Is the person kept alive by life support artificially, or are they allowed to pass away naturally and painlessly? And most people these days feel that they would not want to be kept alive artificially. And if that is how any of you feel, then it's imperative that you have what's called a living will. The living will sort of is a roadmap for your healthcare proxy, and it sets out what your wishes are if you ever find yourself in that sort of circumstance where there's zero quality of life. And I'm going to tie this into the healthcare proxy this way. I've seen this over the years too often, and I always want to warn people about appointing an appropriate healthcare proxy. I've had clients who are very adamant that they would not want to be kept alive via life support, and they've appointed a healthcare proxy to make that determination for them. But the person that they've appointed has some aversion, some personal aversion to removing someone off of life support. It's just against their principles. They can't bring themselves to do it. They're against the idea of removing life support. And look, while I respect all points of view, certainly, and everyone is entitled to their own opinion on this issue, and there's no right or wrong, it's important that whoever you appoint is going to be able to carry out your wishes for you in a way that you would want, right? It's no good if you appoint a healthcare proxy who's going to be unwilling to remove you from life support if that's what your wishes are. So my point is, when you're thinking about appointing a power of attorney and a healthcare proxy, a couple of ground rules. Number one, talk to them. Talk to your proposed person. Make sure that they're willing and they're able to serve on your behalf. You don't want to appoint someone who's not going to be a doer, right? You want to appoint someone who's going to do things efficiently and take care of your matters as efficiently and as practically and as quickly as possible. You want to appoint someone who is younger than you, ideally, right? We don't want to appoint someone who will not outlive us. We don't want to appoint someone who's not trustworthy. That's probably first and foremost. Someone who's trustworthy, honest, younger than us, willing and able. And, do they have to be local? Do they have to be in your state? Not necessarily. We have clients who appoint people who are in different countries or across the country to serve on their behalf. There's no requirement, at least in New York, that the person be physically in the state that you are in. That being said, is it preferable that the person be local? Sure. It definitely makes things easier sometimes. But, the world is small these days and things can be done virtually like we're doing right now. And things can be done via email and telephone. So it's not a requirement. It's not a bold, bright line rule that your agent has to be local in your state. So that's the power of attorney, healthcare proxy, and living will and guardianship in a nutshell. And this is relevant to Alzheimer's disease, as many of us have the unfortunate occasion to know. When someone who we love is diagnosed with the disease, if they haven't planned properly, their situation can become catastrophic quickly. So, for those of you who have family members who are suffering or at the beginning stages, make sure that they have their documents in place. There's really nothing more important than that. And that brings me to, the next topic, which is Medicaid, which I know a lot of you are curious about. So, just to talk about Medicaid globally for a few minutes, Medicaid is different than Medicare. Medicare is available to everyone who's over the age of 65, right? Just by virtue of being 65 or older, you're entitled to Medicare, which imparts various medical benefits to us, which are really critical and really help a lot of people. Medicaid, on the other hand, is a means-based program, meaning you're only eligible for Medicaid if you meet the resource and income requirements. In New York, you have to have less than $15,900 in your name and about $1,000 in income per month. And if you meet those two criteria, you are eligible for Medicaid. Now, those rules vary significantly state by state. So for those of you who are interested in doing some Medicaid planning, definitely speak to a lawyer in your local jurisdiction, because the rules are probably going to vary with respect to income and resource limits and whatever else. So, be sure to speak to someone local if you're planning on engaging in this. But Medicaid is a federal program based, federally, and it's modified by the states, right? So New York has its own set of rules, Florida has its own set of rules, and they vary all the time. So just because the rule is the way it is today doesn't mean it will be the same next year. They're constantly changing. And what do we mean when we say Medicaid planning? And I'll explain it this way. So in New York State, nursing homes cost about $15,000 to $20,000 per month, which is enormous. And you can just imagine that if someone is in a nursing home, it's just a matter of time before their assets are depleted, even if they have significant resources. When you're spending something like $15,000, $20,000 per month, assets become depleted quickly. So when someone is in a nursing home and they spend all of their assets, Medicaid will commence paying for their care, which is fantastic, right? Because they're under the resource limit, at least in New York State. They have less than $16,000. So Medicaid can start paying for their care. for the rest of their lives, which is great. The problem is, upon the death of the Medicaid recipient, Medicaid will have a lien on their estate, which means if there's anything in their estate, before it goes to any of their heirs, Medicaid will say, hey, wait a second, we need to be repaid for the $5 million or so, hypothetically, that we paid towards your care while you were alive. So before your heirs get a dime, we need to be repaid. And this is extremely offensive to a lot of people, understandably so, because, you know, for most of us, our primary asset is our home, right? It's our most expensive asset. It's the asset that we've contributed the most to. And the idea that the equity in our home would go to the government as opposed to our children or spouse or nieces and nephews or friends or charities is offensive and terrible, you know, to a lot of people, and rightfully so. And I certainly understand and I commiserate. So this is where Medicaid planning comes in. What we can do, and again, the caveat that this will vary state by state, but in New York State, a very common tool that we implement is we create an irrevocable trust. And when I say trust, a trust, you can think about it sort of like a shell, like a vehicle that holds assets, kind of like a corporation, right? So a trust is an entity that we can create and we can fund it. We can put assets into it. So if I create an irrevocable trust and I put my home into the irrevocable trust, then I no longer own my home. My trust owns my home. And after a period of time, in New York State, it's 5 years. In other states, it probably varies. But after the period of time relative to your state, if an asset is owned by an irrevocable trust, it is no longer considered an asset for Medicaid eligibility purposes. What I mean by that is, let's go back to my hypothetical, my catastrophic scenario, where I'm in a nursing home and I've spent all of my money and Medicaid is paying for my care. If I had put my home into an irrevocable trust 5 years or prior, it's completely protected and sheltered for my family or friends or neighbors or charities for my estate. And Medicaid cannot touch it, which is a really powerful mechanism to preserve assets. And, you know, it doesn't have to be my primary residence that goes into the trust. It can be really any asset that I want. It can be my investments. It can be a savings account. It can be stocks. It can be, you know, an insurance policy sometimes. We generally do not put retirement accounts into trust because at least in New York State, retirement accounts are exempt for Medicaid purposes, meaning, you know, if I have $1 million in an IRA and I'm over 70 and a half and I'm taking my RMDs, my required minimum distributions, my retirement account is completely protected. Medicaid cannot touch it. So that's a really nice tool as well to shelter assets, have them in a retirement account that is distributing RMDs. But we don't put retirement accounts into a trust generally because retirement accounts, A, are exempt, and B, often have beneficiaries on them because there are benefits to having beneficiaries on retirement accounts. And I can talk about that for a long time, but I don't want to bore you all with that. So let's just recap. And I know a lot of that was a little bit cumbersome and maybe a little bit complex, but you know, for those of us who have people with Alzheimer's in our lives who have just developed the disease or, you know, or perhaps in a more advanced stage of the disease, it's imperative that we plan. How do we plan? Primarily, we have a power of attorney and a healthcare proxy and a living will. In some states, I forgot to mention, the healthcare proxy is sometimes known as the power of attorney for healthcare. So if any of you have that, it's likely going to be synonymous with the healthcare proxy that I'm referring to. But we should have a power of attorney, a healthcare proxy, a living will. And, you know, for those of us with assets, with resources, you may want to consider how you might plan for an eventual Medicaid application. And the way that, typically we plan for that is by use of an irrevocable trust, which I touched on. And other states have different mechanisms for Medicaid planning. So definitely speak to, a lawyer in your local state if you have more questions. But for those of you with questions in New York, you can absolutely reach out to me, and I'm happy to discuss any or all of this stuff with you guys. So I think I'll probably turn it over to Laurel for some questions. If there's something that you're wondering that I didn't touch on, I can't cover everything in 30 minutes, but if there's something that you'd like me to speak about, by all means, let me know and I'll try my best. And Laurel, why don't we take it away with questions?
Yes, absolutely. Well, first, Matthew, I want to thank you so much for your thoughtfulness in this presentation. I really do appreciate it. We actually spoke before this started that both of my parents are actually lawyers as well, and all of this stuff seems very complicated, very complex to me as well. So I appreciate you taking things that I think can be seen as complicated and making them far more digestible and easy to understand, because this stuff can be very confusing. So first, I want to thank you for that. And second, the questions are just flowing in. So thank you all so much. Wonderful questions that we will definitely not get to all of them, but we will try and get to as many as possible. Even as I'm saying it, the questions are just pouring in. So you all are great. So let's just dive in. One question is it best practice to have more than one child on as power of attorney?
That's a really good question. And there's no right or wrong answer there. It really depends on what the family dynamics are. Do the children get along? Is there going to be a possibility of conflict among the kids if you're only appointing one versus both? It really depends on the dynamics with the family, right? I generally am not opposed to having multiple people serving together as power of attorney. I think that sometimes is a great idea. Why? Because they can divide up the responsibilities, which can be helpful. And if one of your children is local in your state and another one perhaps lives, across the country, it would behoove them to be able to work together. Perhaps the one who's local can do the running around, and the one who's a little bit further away can do some of the back office type stuff, so they can share the responsibility. I wouldn't suggest appointing, more than 2 or 3, because you know what they say about too many cooks in the kitchen, right? So, but it really depends on the individual family dynamics.
Yeah, I think that's a great point. Absolutely. I have someone here who mentioned that their husband was recently diagnosed with mild Alzheimer's disease. He always managed money very well up until about 1.5 years ago when the Alzheimer's symptoms began. About 1 year ago, this person learned that he was entering hundreds of charity labeled sweepstakes writings, 10,000 or 10 writing either 10,000 or $10 to hundreds of these. In January alone last year, he gave over 1,500, mostly in $10 checks, $1,500, okay. Needless to say, he could no longer balance his checkbook. I've asked him to stop many times, even showing how bogus some of them are, and it's not working. I have a POA. How do I stop the bleeding?
Well, I'm so sorry about the circumstances, first of all, with your husband, and I hope it all works out. The good news is that your husband and you have planned appropriately, right? Having the power of attorney is really the most critical step. So you've taken that, which is really great to hear. If you feel that your husband, is losing the ability to handle his finances appropriately. And if the money coming out of that account is in his name alone, what you can do is record the power of attorney with the bank. When I say record, that's the process of bringing the document to the bank. They will review it. And once they approve it, they will add your name to the account as a signatory, and then you can transact on that account. And then, you might want to, there are a number of things you could do to safeguard the money. You could close the account and reopen an account in your own name. You could limit the amount of money that is withdrawn from the account at one time to limit these expenditures. If you feel that there's no other recourse but a guardianship, even though you have a power of attorney, if your husband's really fighting you, that might be an option too. There are so many, things that I could say about that scenario. One anecdote I'd like to tell you is, which reminds me, I had a client a number of years ago who his wife had passed away from Alzheimer's, and he was very distraught, of course, needless to say.
Mhm.
And he was a wealthy man, and he got a phone call one day, and the caller said, "You've won the lottery, Bill. All you have to do is send us a check for $100,000 to
Wow.
prepay the taxes on the winnings, and then we'll send you your winnings." And he said, "Fantastic. Where do I send the check? Who do I make it out to?" And he did. And that's not the worst part. Obviously, that was a scam, right? But even worse than that was, once they realize that they have a live one on the wire, if you know what I mean, they don't stop there. He got continuous phone calls day and night. He got letters in the mail from the scammers. He had people show up at his door pretending to know him from 50 years ago who were part of this scam. One of them moved in with him. It was an absolute nightmare. Thankfully, we were able to get involved and get the court involved and protect him and and really save him financially and otherwise. But I guess my point is, with these sweepstakes, certainly some of them might be scams. So you probably I think you're asking the right question. You definitely want to safeguard that account, because even though the money is relatively nominal at the moment, who's to say what it will be tomorrow? It could increase significantly.
Yeah, absolutely. I have someone who asked if you'd be able to speak on spousal refusal and the transfer of assets during the Medicaid application process, and when that is and is not appropriate.
Yes, I will talk about spousal refusal briefly, only because it's only relevant in a number of states. New York is one of those states. But most states in the country do not allow for spousal refusal. What is spousal refusal? Spousal refusal is a concept where the state will allow an unwell spouse to transfer money to the well spouse in anticipation of a Medicaid application. And actually, even beyond that, really what spousal refusal is, it allows the well spouse to say, you know what, even though I'm married, I'm not going to contribute to my spouse's care. So let me give you an example just to illustrate this. If my wife and I are anticipating a Medicaid application, and my wife is very ill and is in a nursing home and needs Medicaid, and I have significant resources in my name alone, I can execute what's called a spousal refusal. And I could say, you know what, even though I'm married to my wife, I'm refusing to contribute to her care with my resources. And Medicaid will allow that. Medicaid will say, okay, Matthew, we're not going to consider any of your resources towards your wife's Medicaid eligibility. So as long as she has less than $15,900 in her name, we don't care how much you have. You could have $10 million in your account. We're not going to consider it. Which is interesting, right? Most states do not allow this. New York is one of the few states that does. The issue that sometimes comes up with spousal refusal is, even if I exercise my right for spousal refusal and my wife is receiving Medicaid, Medicaid can sometimes, knock on my door 3, 4, 5 years down the road and say, hey, Matthew, we know you executed this spousal refusal, but we need you to help contribute. We see that you have a lot of money. We're allowing your wife to be on Medicaid, but we need your help. We need you to help contribute to her care. And, sometimes, the well spouse will have to pay up. Sometimes that sum can be negotiated, sometimes not. But that's the concept of spousal refusal. It's basically Medicaid will not consider one spouse's income and resources with respect to another spouse's Medicaid eligibility. I hope that makes sense, and I hope that's clear.
Yes, absolutely. I don't know if I ever even heard of that before, so thank you for that.
Sure.
Someone mentioned that you discussed, if you put financial assets in irrevocable trusts, do you continue to have access to it? And then additionally, if you could, since you did talk about irrevocable trusts, difficult word, what about revocable trusts?
Great. I like both of those questions. So to address the first part of that question about the irrevocable trust, the answer is no. Once you put assets into an irrevocable trust, you no longer have access to those assets. It's really as if you're giving them away, right? You have to appoint a trustee, which cannot be you. It has to be a third party. And that trustee will be able to manage those assets that are in the trust. And those assets cannot be used for your benefit at all. And again, I just want to reiterate, I'm only speaking with respect to New York. The rules may vary in other states, but at least in New York, anything that is in an irrevocable trust for Medicaid purposes, I no longer have access to if I'm the creator of the trust. They cannot be used for my benefit. I can't touch them. I can't take them out. It's irrevocable. So, that's the main concern that many people have when they're considering an irrevocable trust. Are they willing to part with control of their assets? Often it makes a lot of sense if there is real property or a co-op apartment or something of that nature to put that into trust, because the person still gets to live there in their home and they still pay the carrying charges and, the mortgage, if there's a mortgage, and the real estate taxes. And nothing changes with respect to their lifestyle, even though their home is in an irrevocable trust. So that's a really great thing. But, if they're considering putting cash or, investments into an irrevocable trust, they're going to lose access to that. So you want to be careful that you're not depriving yourself of cash flow and the ability to maintain your lifestyle by creating an irrevocable trust. So, when we do this for clients, we always strategize with them about how to fund the trust appropriately and what monies to put in and what monies to keep out. So I hope that answers the question about irrevocable trusts. And I think there was a question about a revocable trust, which is a very different concept. A revocable trust is freely revocable, amendable, changeable at any time. And anything that you put into a revocable trust, you still have access to. You can take it out, you can put stuff in, you can change the terms of the trust, you can change your beneficiaries, you can change your trustee. It's completely amendable. But, of course, a revocable trust really has no asset protection component to it. It does not protect assets whatsoever. The only real benefit to a revocable trust is to avoid probate. Now, probate is a word that many of you, I'm sure, have heard about. Probate is the process of the local court validating someone's will. Probate means validate. It comes from the Latin. So probate is when a court validates somebody's will. And this process varies significantly state to state. New York has, I would say, probably one of the most cumbersome and complex probate proceedings out there. New Jersey, for instance, has a very streamlined, very easy probate proceeding. And other states, have simple processes and more complex ones. So, but if anyone has questions about probate, we can certainly discuss that. But a revocable trust has one benefit, and one benefit only usually, and that is to avoid probate.
Okay, thank you for that. Yeah, the questions just keep coming in. So this is really great. Thank you, everyone. Someone wanted to know, oh, but I just lost the question. That's okay. I'll find it again. Are there any tax impacts of moving home to an irrevocable trust or moving things around in an irrevocable trust?
That is really it's a good question. It's a complex answer. And I definitely, for any tax related questions, I always advise clients to, speak to their tax preparer to make sure that they're doing everything appropriately. But yeah, let's talk about this issue comes up a lot with respect to tax. If we're talking about our home, especially in New York City, I have many clients who purchased an apartment in the 1970s for next to nothing, and now it's worth $5 million.
Yeah.
Obviously, that level of appreciation doesn't exist everywhere, but if you live in an urban environment, then you may commiserate with that. So on the one hand, all of that appreciation is wonderful. On the other hand, it can really come with some significant tax implications. For instance, if someone is to sell a highly appreciated asset like an apartment, they are going to be subject to what's called capital gains tax. So the government will tax all of the gain that they made on the asset. There is a credit that everyone has of $250,000 as long as the asset is their primary residence for, I think, 2 of the last 5 years. But notwithstanding that, if you're selling a highly appreciated asset, you're going to want to be weary of capital gains tax. So, with respect to an irrevocable trust and those tax implications, what we do in New York is we create what's called a grantor trust. And not only that, we structure the trust so that there is a step up in cost basis upon one's death. And I'll try to explain this as simply as I can. Mm-hmm. Let's go back to that $5 million apartment example. So if Laurel was lucky enough to purchase an apartment for $100,000 in 1975, and now it's worth $5 million, and she turns around and sells it, let's say there's $4.9 million in capital gain, and that's going to be subject to about 25% tax when you consider state and federal. So it's enormous. But on the other hand, if Laurel keeps that apartment for the rest of her life and never sells it, when she dies, the apartment gets a step up in cost basis, which means that for capital gains tax purposes, the government no longer cares what Laurel paid for it in 1975. The value gets stepped up to her date of death value. So all of that gain is completely wiped away. And all of that tax exposure is completely wiped away for Laurel's heirs, which is fantastic. There was for those of you who follow Congress, there was some talk recently that they were thinking about doing away with the step up in basis rule. And, I haven't heard anything about it in a few months. I think that it was really quite unpopular. A lot of people really rely on that to transfer wealth. But this has been in place for decades. And I think they've tried to repeal it over the years, many times unsuccessfully. But this is a very powerful tool for those of you who have an appreciated asset. And this goes for stocks. If you bought Apple at $5 a share and it's split 20 times, and now, if you spent $10,000 on Apple stock and now it's worth $1 million, same story. If you were to sell it now, you're exposed to capital gains tax. But if you keep it for the rest of your life, the value gets stepped up to the date of death value, and all of that gain is wiped away. So, and I'm sorry if I went off on a tangent here, but whenever you're thinking about irrevocable trusts, you want to structure it in a way that you're going to maintain that step up in basis upon your death. So definitely speak to your tax preparer and your local attorney for more information on that.
Mm-hmm. Yeah, no, that's very interesting, and you did explain it in a simple way. I again, had no idea about any of this stuff. So this is why I like these care connections, because I get to learn so much too, which I mean, isn't that the point of all of this? So yes, that's wonderful. Thank you.
Sure.
Someone asked another really great question. When does a person lose capacity to execute a healthcare proxy or a living will?
Yeah, I like that question. That answer really varies state by state. Each state has their
Mhm.
own laws with respect to someone's capacity to sign documents. Um, so I'm not going to answer that specifically. It really is dependent upon where you live. Um, in New York, in terms of signing a will, which is usually where the question of capacity comes into play, in New York, one has to know in general who their family members are and what their assets are in a general sense. The person doesn't need to know their account numbers off the top of their head or the exact dollar amount down to the penny in their account, but they have to be able to say in general terms what they own. And that's a really low bar. Even someone with a diagnosis of Alzheimer's can certainly have capacity to do a will or a
Mhm.
healthcare proxy or a power of attorney. A diagnosis does not automatically mean that they've lost capacity to sign documents. So, for more information on that, definitely speak to a local lawyer or look up your local rules because they're going to vary state by state.
Okay, awesome. Thank you. And someone mentioned that their mother has a power of attorney and a healthcare proxy, and this was done in New York State. Their mother moved to Maryland. So this person was wondering, do we have to redo these forms, redo power of attorney and healthcare proxy since their mother has moved?
Yeah, that's a really common question. I'm glad you brought that up. The answer is generally no. If you've done a document in state A and it was done validly there, and then you move to state B, the documents from state A are going to still be effective.
Mm-hmm.
Every state recognizes every other state's documents, so long as they were done properly. And, but look, that being said, is it good practice perhaps to, redo them in your local state? Probably, right? Because, forms vary state by state, especially with regard to the power of attorney. I'm a fan of the path of least resistance, right? If I'm going into a bank and trying to record a power of attorney, I'd rather have in hand a document from that state. So the bank is more likely to recognize it immediately, and it doesn't have to sit in the legal department for a month before they come back with an answer. So if your mother is capable and it's not too much of a hassle, it might behoove you to redo the documents in your new state or her new state. And another thing is documents like this never expire. So if you've done a healthcare proxy in 1951, I don't know where I pulled that year out of, but it's completely valid still. They never expire. But again, a document that's 70 years old, who knows? Who knows who's going to recognize it? It may not even contain witnesses, or the requirements of the modern day. So even though they don't expire, it probably makes sense to update them from time to time.
Mm-hmm. Yeah, that's a great point. And then someone asked, do we need an attorney to set up a trust?
I knew this question was going to come. This question comes up all the time.
Okay, good.
The answer is no. You do not need a lawyer really for any of this, right? You don't need a lawyer to do a will. You don't need a lawyer to do a healthcare proxy or a trust or a Medicaid plan or anything. You also don't need a dentist to do a root canal, but I probably would recommend that you use one. That's my root canal joke that a lot of you have probably heard. But in all seriousness, no, you don't need a lawyer. But that being said, with something as critical as a trust or a will or a healthcare proxy or a power of attorney, which generally speaking, are usually pretty nominal in cost. To risk doing it without a professional, I wouldn't recommend.
Mm-hmm.
Because I've seen so many homemade wills. I'm dealing with a few of them now that are going through the probate process. And, people, think that they might save a few bucks by doing it themselves. But the reality is, if one clause is misworded, or one word is left out, or one sentence is misplaced, or a signature is in the wrong spot, it could create thousands, tens of thousands of dollars in legal fees,
Mm,
to rectify that mistake in the probate proceeding. Or, what if the trust is invalid for some reason, especially if we're talking about an irrevocable trust for Medicaid planning? What if Medicaid looks at the trust and says, this trust wasn't done properly. We're not going to recognize it. It's as if those assets were never transferred and now they belong to you and now they're subject to Medicaid, right?
mm.
I mean, the idea that we would want to risk that, um, without the help of a professional, it doesn't strike me as prudent, right? So the answer is you don't necessarily need it, but I would recommend it. And I'm not just saying that because I'm a lawyer. I really feel that.
Yeah, yeah, absolutely. Well, we talk a lot about here at AFA and on the helpline when we're, having our educational presentations. Our goal is to make things as simple as possible. And then sometimes that does mean, doing legwork at the beginning, if that can make things simpler later on in the process. It's keeping things as simple as humanly possible to just make life, make decisions just a little bit easier. So thank you for that. Someone mentioned that their mother has a trust. They believe that it's irrevocable. Wouldn't the mother be able to trigger a financial POA, this person's sister, by signing a document for a lawyer and adding that to the trust? How does this work? And that they want to try and do this quickly before her short-term memory loss turns worse.
I'm not exactly sure that I understand the situation based on that question. It sounds like a really discrete issue.
Mm-hmm.
If you want, the person who asked that can feel free to call me, and
Okay.
I'm happy to talk it through with them, no charge. Laurel can probably distribute my information to everybody.
Yes, I will. Yes, of course.
So yeah, I'm happy to help with that. I would really need more information before I even venture a guess as to an answer.
Okay. Yeah, no, I appreciate that. Someone asked, do people with Alzheimer's have to have a huge involvement in setting up a trust if someone has a POA? This person is not sure if their parent is competent enough to set up the trust.
Yeah, I like that question a lot. So just to reiterate what the question is, so everyone understands, I think the question boils down to, if someone has a power of attorney, can that agent under the power of attorney sign a trust for them on their behalf? And the answer is, it depends. The famous lawyer answer, right? It depends on if the power of attorney grants the agent that ability. Assuming that it does, then yes, an agent can execute a trust on someone else's behalf. But the linchpin to that answer, what it hinges on, is the power of attorney must impart that ability on the agent. So to answer your question, you would have to look at that power of attorney and see if it allows the agent to create trusts on behalf of the principal. And if the answer is yes, then the agent can sign a trust on their behalf.
Mm-hmm. Okay, and in the 6 minutes that we have left, I have another question. And again, I am so sad that we cannot get to all of these. But unfortunately, if we did get to all of these, we would be here well into the evening. So I'm just going to have us touch upon this one for last. If you'd be able to talk about community Medicare and Medicaid.
Yeah, thank you for that. I say this every question, but I think all these questions are so great.
Very good
Um,
questions.
a lot of good ones. So there are two types of Medicaid. There is institutional Medicaid, which is nursing home Medicaid, which we talked about. And then there is community Medicaid. Community Medicaid is where Medicaid will pay for home health aides to come to the home and provide care. The rules for eligibility vary between institutional and community Medicaid. For instance, in New York, there is presently no look-back period for community Medicaid. So I could be a millionaire today on Thursday, and tomorrow on Friday, I could transfer all of my millions to Laurel. And then on Monday, I could be eligible for Medicaid, for community Medicaid. And they don't care that I made those transfers. There's no penalty. Now, just as a side note, they are changing that law in New York. It's being implemented shortly. But as we sit here today, that is the rule. Whereas in New York institutional Medicaid, I'm subject to that 5-year look back. So any transfers that I've made within the last 5 years are going to render me ineligible for Medicaid. And again, I know I keep repeating this, but please speak to counsel in your local state because these rules vary state by state. But community Medicaid, again, is where the government Medicaid will provide home health aides for us in the home. I will say that most people want to stay at home to the extent that they can. Even with very, very, very advanced Alzheimer's disease, it is possible to stay at home. It's often more comfortable. It's often less expensive. And for those of you who, I'm sure most of you know this, who have dealt with an Alzheimer's patient before, when you remove someone from their environment and their comfort zone, it often can exacerbate the disease. It's preferable usually to keep someone in their environment, in their place that they know and they feel comfortable in. So for that reason, community Medicaid is really preferable for a lot of people. And I will tell you that, by and large, we can keep most people home these days. I would say 90% of people who need help can stay at home. It's really only the most extenuating of circumstances that require a nursing home. And again, that also varies. If someone lives in a studio apartment, it's going to be difficult to have care there around the clock. But if you live in a large home and there are multiple bedrooms and there's a lot of space, staying at home is a viable option. So that's really the difference between community Medicaid and institutional Medicaid.
Okay, wonderful. I feel like we could keep talking about this for much longer than an hour. However, for the sake of literally everyone's time, I think we're going to have to end it now. But I really first just want to thank you again, Matthew, so much for your thoughtfulness. I feel like you are an encyclopedia of very important information. So I am very, very, very grateful. So thank you so much for taking the time to speak with us today. I really do appreciate it. Sorry.
I was just going to say it's my pleasure. I'm always happy to do it. Thank you for having me, and thank you for the wonderful questions.
Yes, absolutely. So now this is my time to thank all of you who attended, for taking the time, for wanting to hang out with us here at AFA for an hour. We are also grateful for you as well. If anyone ever needs anything, please feel free to call our nationwide toll-free helpline. And at AFA, we're here for all of you. I'll be sending you an email after all of this, so please feel free to contact me, send us any questions you may have. And in the meantime, we are very excited and looking forward to our next Care Connections. April is a big month. We're having 2 Care Connections in April, so that means double the fun, so get excited. On April 14th from 1 to 2 p.m. Eastern, we'll be having Dr. Brant Courtwright and learning about functional psychology for peak brain performance. And then on April 28th, we're going to have Karen Peterson discussing a program that she created called Move with Balance, which will be really exciting on how we can incorporate healthy aging activities, not only for our body, but for our brain. So please be on the lookout for our April Care Connections. And so thank you, Matthew, thank you, Raphan Law Partners, LLP, and thank you to everyone who attended today. It is always a pleasure, and I hope to see everyone next time.
Thank you so much, Laurel.
Bye, everyone.